Judge, we still need one more discovery setting, please.
Okay.
The second thing, once you have a minute, once you choose a setting, then we did have an ELM discussion that we'd like to have too.
Okay. All right. So Norma, recall this for discovery on December 19th. Yes. All right.
Going back to the ELM discussion,
Mhm.
we talked about a month ago when we were here.
Mhm.
And the court has a motion on file to remove her ELM, mostly based on work employment issues. She does not have any other criminal history other than this case right here. And that the court asked her to get a letter from somebody who would consider hiring her. So she has. The court's request was that we bring it back in for you to take a look at.
And so have you a chance to review this letter?
I have not, but it's.
State, do you have any objections to removal of the GPS?
Yes, Your Honor.
All right, we'll go on the record. Court is calling 2024 CR 0082388A, State of Texas versus Tiffany Martinez. Can I have parties announced for the record for the state,
Jason Bearhead.
for the defense?
Jim Wheat,
And are you Miss Martinez?
Yes, ma'am.
All right, we're here to hear your request to have GPS removed. What I can tell both parties, and this is what I want to focus on, in the letter, it says that they did not want her working there because her GPS monitor was noticeable. Is that correct in my reading of the situation?
So I was told that they were gonna fire me because of the GPS monitored, just because it's on my ankle, not just because it's visible.
All right, that's not what the letter says. The letter says that the GPS is noticeable. Did I read that incorrectly?
yeah, she was let go because of that, but they're willing to take her back if it's on.
All right, but the reason why they're saying she was let go is because the GPS was noticeable. If I'm reading the letter incorrectly, somebody let me know. But that's what it says to the court. Am I wrong?
That's my understanding of that.
All right, so if they're letting her go because the GPS is noticeable, and my understanding the GPS is on the ankle, then that problem can be solved by long pants. Am I wrong?
Yes, because we wear scrubs. They are joggers, so they're not flare scrubs.
Oh, no, they're long. I've seen, this
No,
is me interjecting, but I've seen scrubs.
Yes, ma'am, but we have a dress code with the company that it's joggers with the logo of it's the gray.
This opening sets the stage for the case, introducing the defendant and the problem caused by her visible ankle. GPS. It immediately creates tension around her job and the legal system's role in her day-to-day life.
The Grey's Anatomy scrubs that they provide for us, so they don't have the flare.
Judge, as soon as she sits down to do her job, then the pants are going to come up enough for somebody to see it. And so I just don't know that there's a way to get around it. Be noticeable. It's just going to be noticeable.
All right, so first thing, my understanding from the letter, the reason why she was released is because the GPS was noticeable. Am I correct in my reading of the letter?
Yes.
All right, so then the other question becomes, why can't she just wear long pants? I don't understand.
Because they don't provide the flare pants. We have a dress code policy that we have to follow, and they provide the joggers. So it's cuffed scrub pants versus flare, so they won't allow me to work there with the monitor because the dress code is jogger, not flare, so it's won't be able to be covered at all.
All right, I'll hear argument. The state.
State is opposed to release of the GPS or removal judge due to the severity or degree of the crime.
I will only point out to the court again that she has no other history. I mean, absolutely, completely clean. But the case, it took the state over a year before they actually indicted her, which tells you a little bit about the case. I think that given the fact that the state didn't need to go forward sooner than that.
The courtroom officially opens the legal argument as the judge scrutinizes the employer's letter and questions whether the GPS visibility truly justifies termination. Stakes rise as both sides prepare to argue over her future.
Than that should tell you if there's any problems. In addition, there have been no problems or reports from the complainant in this case. And so there's no problem with her having anything but a no contact order from the court. And she will follow that as she has since she's had the money.
All right. And State, have you spoken with the complainant?
Not today. I just became aware of this. Well, I know that Mr. Wheat may have presented this previously, but today I have not talked to the actual victim in the case.
All right. So State, if you can reach out to complainant, because I don't know anything about the case other than what the charges are. And based upon what the charges are, it appears that the GPS should remain. It appears that maybe your company should work out something since they want you there, where they can make an exception for you about pants length. But if we can see if there are any concerns or issues with the complainant with her not being on GPS.
Sorry to
Yes.
interrupt you, Judge. I just got notified by co-counsel that the advocate of our case, Rose, has been contacted by the victim. The victim may propose any type of GPS removal.
All right. So then the next thing is to see whether or not, because it appears that they want you desperately to be there, to see if there's any way that they can make an exception for you with regards to your pants length. And then what I will do, since it appears that there are no violations.
A seemingly simple issue, clothing becomes a legal barrier. The court dives into the dress code dilemma that prevents hiding the ankle monitor, showing how small details have big consequences in real lives.
You can work whatever hours they provide for you. So if there's an issue where they won't make an exception with your pants, then let the court know. Okay. All right. So we're coming back on December 19th for discovery. The removal of GPS for now will be denied. Is there anything else?
Nothing in the state, Your Honor.
No, Judge.
All right. Once you sign the reset form, you're excused. Thank you. So what are we here for on this case?
Judge, this is the second setting she's had since she's been indicted. The case took over a year to indict. We're still waiting on discovery and trying to get that together.
Okay.
So we're just asking for one more setting to be able to do that.
All right. And so discovery.
As far as I'm aware, Your Honor, all the discovery has been tendered and
Well, I just had a notice of additional stuff last night, so.
All right. So this is going to be the final discovery date. States, you need to make sure that everything is uploaded.
Yes, Judge.
Ms. Ferguson, if you'll put this at the end of January. All right, January 28th. All right.
Thank you, Judge.
You're welcome. Once you sign the reset form, you're excused.
The judge hears both sides, the state's concerns versus the defense's appeal, citing the delay in indictment and the clean history of the accused. This moment weighs liberty against caution, adding serious tension.
Excuse. And thank you for dressing appropriately for court. All right, so this is final discovery. Has all of the discovery been received? And I will need a discovery acknowledgement if the court doesn't have one before you all leave today. And Norma, I need a plea deadline. How old are you?
I'm 26. I'm almost 27 next month.
Okay, well, hey, happy birth month in advance.
Thank you.
Ms. Ferguson, I need a reset date, plea deadline date in 3 weeks, please.
What's your birthday?
February 18th.
Oh, no.
Is that your birthday? Okay, that'll be the day before birthday, Judge.
There we go. So February 18th is your plea deadline date. On that date, you need to let the court know whether or not you have reached an agreement. If you have not, your next court date is going to be a jury trial. All right, thank you. Once you sign the reset form, you're excused, and thank you for dressing appropriately for court. So has all discovery been received?
I'm not sure, did you?
The victim's objection changes everything. The judge holds off on removing the GPS, forcing everyone to reconsider their positions and making this the emotional and legal pivot of the case.
Did y'all discuss what was missing last week or last setting? I'm not sure.
I'm not aware.
I think we have everything we need, Judge. I received an offer today. So I would like to get a reset to go over that with my client and review the discovery with her.
All right, how old are you?
She's very sick today.
Oh, well, please. Do you need a mask? Oh, well, don't stand next to people. All right. She needs a mask. And Norma, set this for a plea deadline date on December 9th.
Yes, ma'am.
All right, once you sign the reset form, you're excused.
Thank you, Judge.
Thank you. Hello.
Hey, good morning, Judge.
Hi. So was she accepted in a mental health court?
Yes, Your Honor, we're happy to announce that she was accepted on January 17th. She has her next felony mental health court setting this Friday in the 379th, Judge.
375th?
379th.
Okay.
Yes, 375th. I'm like, where would that be? I need to,
All right.
I need to see.
So has she officially been transferred there?
I don't believe the case gets, I mean, I think y'all's court doesn't transfer the file over there. I guess, right? Felony mental health court, you guys keep it here and kind of status it, right?
The status here and then,
The final stretch wraps up key decisions, plea deadlines, discovery, and a mental health court update. Shows the court's procedural side, but also a glimpse of support, humanity, and ongoing accountability.
379 takes care of it.
Takes care of it.
But no, had she already had a appointment there? Does she have a next court date there?
Yes, Judge, it's gonna be this Friday, the 31st. Is her next court date.
Okay. All right, then.
So Judge, oh, sorry, I was just gonna ask that she's been doing really well, Your Honor. She's been attending court, she's been doing outpatient, and now she's gonna be doing mental health court. If we can get a little leave in terms of a status, perhaps maybe halfway through, just to check how she's doing.
Okay. All right. Nora, set this for May 27th.
You said May 22nd,
27th.
27th.
All right, so we'll bring you back on May 27th to make sure everything is still going well. And if everything is still going well, then we'll spread it out even further.
Great, thank you so much, Your
All
Honor.
right, is there anything else?
Nothing further with regards to Ms. Aaron.
All right, good luck to you. Thanks for dressing appropriately for court. Once you sign the reset form, you're excused.
Hey, Bob. I have an